So, with all of that said, I'm going to now turn it over to our host for today. This is Eric Malloy over from ACAM. Eric, thanks again for having us. It's all yours, my man.
Jeff, thanks. It's always a pleasure to do these. Great topic today. Really looking forward to jumping in and hearing everything that Emily's going to offer up today. ACAM, we're a management company, so we've been in business now for 43 years. We handle all aspects of community management, so your management program, maintenance, janitorial, compliance. Compliance being a big issue now in the state of Florida with all the changes. So for us, ACAM, we're very dedicated in bringing education, not just to our clients, but to the industry as a whole, right? Educated board members are the best resource for your associations. Listen, it's a volunteer role. We understand that. And you guys need to be kept up on all the changes that happen on a daily basis. So it's really our pleasure to partner with great firms, great speakers, bring you the content so that you walk away as educated board members. My information will be up there if there's any questions. I'm really going to turn it over to the expert. Emily is going to keep you guys enthralled with a great subject today. I hear this topic brought up to me a lot from board members. It is something that is on everyone's mind, but it really can be a little bit of a minefield to navigate if you don't have the proper information. So with that, I'm going to put it right over to the expert. We're going to jump in feet first. If you guys have any questions, I'm always available. My information and contact will come out at the end, and we're off and running.
Thank you, Eric. All right, guys, hold on. Let's see if I can just share my main screen here first. Let's start there. All right, where's my there we go. All right. All right. So, topic today, guest restrictions. Now, my name's Emily Gannon, as they both so kindly said. I'm with K. Bender Rembaum. We are an association firm. This is all we do is represent and work with condos, co-ops, HOAs. So I know today's credits are really more for the HOA and for CAMs, but obviously if you're a board member on a condo or in a co-op, this information is still going to be helpful for you. I know you're not going to get a credit, but still helpful for you. So please sit tight, and it's really only an hour. So, enjoy. Let's hang out. Now, today's topic, as Eric said, it's become more of a hot topic in recent years. I think also we are in South Florida. I'm based in our Pompano office. We do have offices basically throughout the state, but South Florida, again, you kind of see the rise in housing prices. So you see more changes in based on our population because of that. People moving in with family members, things like that. So all of those things are kind of outside forces that make this a more relevant topic today. But let's dive in. So we're going to talk about guest restrictions, screening tenants, new owners, all of those things that come with this. This one isn't very slide heavy. We kind of have some slides, and it really is going to be more of a conversational thing, and we're going to go through a bunch of topics. So like I said, keep the questions till the end. Please don't give me, a very specific question about your association. Keep these pretty general and on topic, and then we'll do some questions at the end. All right, let's start. Okay, there's my little profile if you need it. So what are we really talking about today? We're talking about screening and guest restrictions, what this means. Can we screen new owners, new tenants, prospective owners, prospective tenants? What about guests? Who are guests? How do we define guests? We're going to get into all of that. Can we do that as a board, as an association? Do we have that authority? I'm going to tell you, and you're going to hear me say some of the same things kind of over and over again. The big takeaway from today, I'm going to tell you, is you have to review your governing documents. This is an interesting topic because the statutes don't really give us guidance. So really, this is something where your governing documents are going to be very, very important, and we're going to need to know what your governing documents say. Now, let's get into what that really means. What even are your governing documents? What's the hierarchy of your governing documents? Why do I keep saying the phrase governing documents? That's sort of the all-encompassing package, right? So your declaration, which is either a declaration of condominium, if you're a condominium, or it's your declaration of covenants, restrictions, easements, some variation of those words, if you're in an HOA. Articles of incorporation, your bylaws, then your rules and regulations. That's the hierarchy, right? So that means your declaration is going to control if there's a conflict over your articles, over your bylaws. The easiest way to remember that is that little takeaway commercial that we used to joke about, that a little dab will do you, right? So DAB, declaration, articles, bylaws. These are all different documents, right? So we hear a lot of owners say, hey, our bylaws say this, or this is in our bylaws, or we're thinking about changing our bylaws. So for whatever reason, bylaws has kind of become this slang term that a lot of owners use or board members use, and they really do mean the whole body of governing documents when they say it. But keep in mind, again, there are different documents that have different purposes. Your declaration, again, either of condominium or of covenants or restrictions or whichever, that has your restrictions typically. So that will have the details about if you're a 55 and over community, if you have ARC approval, if you have, if you have guest restrictions, if you have the ability to review sales. That's typically in your declaration. That's where it should be. That's where those things should be laid out. Your articles of incorporation and your bylaws, those are a little different. Your articles are what have to be filed with the state to set you up as a corporation. Your bylaws spell out typically sort of your how many board members you're going to have, what your notice requirements might be for meetings, things like that. But the restrictions that we're talking about today, probably in your declaration. If they're not, if there's something in your bylaws and they're not in your declaration, that may be an issue, and we may have to sort of get some amendments going to straighten that out. But that's something you need to be aware of. So we start there. Your governing documents are the most important thing for this topic today. You need to know what's in your governing documents, because you might think you have certain authority based on, well, we've always done it this way. But if your governing documents don't specifically give you that authority, you may be setting yourself up for some trouble here. If you're doing something without the proper authority, obviously you could be subject to a challenge, subject to legal action. We don't want that, right? So first question is, do you have the right of approval or the right of first refusal? And what does that really mean when we talk about the right of first refusal? Some documents are drafted in such a way where it will say that basically the board has to approve a sale or approve a lease, but it doesn't spell out the whole procedure of a right of first refusal. Those could be very different things, and they have different meanings. The right of first refusal essentially says that the board has the ability to refuse a prospective sale. And if it does so, it's going to provide a substitute purchaser that will step into the shoes of that buyer that it wants to deny. And essentially your seller owner is not harmed. There's no damage because someone is stepping into the same shoes. You're providing a substitute purchaser, the same sale, the same deal is going to happen. Now, the right of first refusal sounds very intimidating because, of course, what do you mean the association has to provide a substitute purchaser? Well, essentially, the way the case law came out, those things need to be tied together. If you want to deny a sale, if you want to tell an owner that they can't sell their property essentially to the person that they want to sell it to, that is a big deal. We'll keep it very simple here in terms of, in the eyes of a court, that is a big deal. The ability to sell your property is again very important. So if the association is going to step in and tell an owner, no, you can't sell your property, the courts have essentially decided that has to be tied to the right of first refusal. You have to be able to, the association has to either be able to say, for essentially a good reason, because this sale does not comply with our governing documents, we can deny it. And in that case, we don't have to provide a substitute purchaser. Or if we're denying it and there's no other reason, we're providing a substitute purchaser. The substitute purchaser could be the association, could be a friend of the association, an investor that they know, someone like that. We've seen it, somebody step in where the board, and usually this is in the world of condos, but not always. Sometimes there's just a deal that sounds, too good to be true sort of thing. The owner's selling the property and they're doing it at such a low rate. The market value of this property is so low. The board says, we don't want to allow that. We can't let that sale go through because it's going to hurt everyone else's property values. We need to step in, provide a substitute purchaser, again, often the association. The association can then buy the unit. step in as the purchaser, complete the sale. Seller is not harmed. The seller got their same deal that they were going to get, essentially. Association steps in, buys the unit at that, bargain basement price. And now the association can turn around and sell the unit for what it thinks is the actual market value. And now the last sale on the books would be something within that market value range. And now hopefully your property values haven't been negatively impacted. That's where we typically see the right of first refusal being exercised, because again, there's no other reason to say no to this buyer. The only reason was that sale price that just the board decided was just too low. If you don't have that right of first refusal tied to the ability to deny a sale, so if that language about the right of first refusal is not in your governing documents, spelling out how this would work, and it is certain language, you'd be familiar with it. It's typically in there and it's a whole long provision. If that language isn't in there and you have sort of one sentence that says the board gets to approve sales, those again are not the same things. And talk to your counsel, because if you're denying a sale and you don't have that right of first refusal language in there, potentially you're subject to a challenge. Those things are supposed to be tied together and you have to have that language in there. Now, right of first refusal obviously scares boards a lot, because they say, well, wait a minute, we want to be able to deny and we don't want to have to provide a substitute purchaser. We don't want to step in and be the ones to buy this property. And you don't always have to, right? So like I said, it's really in the case where you don't have a good reason, and that's how we kind of say it that way. But it's really if that sale is not going to comply with your governing documents, you're able to deny and you don't have to exercise the right of first refusal. And we'll get into that a little bit more in a minute. Now, talking about our governing documents, so that language needs to be in there if we want to deny sales. So the right of first refusal. Another important thing you have to have in your governing documents, does it mention anything about charging fees? Are you charging fees for running background checks? I know a lot of those companies will charge you whatever it is, $150, $200 potentially for a background check. So are you able to pass that on to the owner or the applicant? Possibly. Check your governing documents and see. Now, if you're in the world of condominiums, Chapter 718, so not HOAs, Chapter 718, just condominiums, there's language in there that restricts your transfer fee ability. So a transfer fee is essentially, the division considers it any fee that's paid in connection with a transfer. That includes these application fees, these background check fees, all of that. And there is a limit in the statute, okay? So if you're in a condominium, the statute already limits you, and it's $150, per applicant. And a parent and child are considered one applicant, husband, wife are considered one applicant. And ultimately, your hands are a little bit tied. So that transfer fee is in the statute, and that's only in 718. In HOAs, it's a little different. HOAs, there is no restriction in the statute. You could have a higher transfer fee. So again, that would include an application fee or a background fee or whatever else you're calling it. Potentially, the division would look at it as a transfer fee. And if you're in a condo, you have that limitation. But that language, if you want to charge fees, should be in your governing documents as well. What about security deposits? If we're talking about reviewing leases and tenants, can we charge a security deposit? Good question. Again, that authority should be in your governing documents too. If you don't have this in your governing documents, if you don't have all of this authority in your governing documents, you might be subject to a challenge and potentially some serious issues here. What about down payments? You could have a provision in your governing documents that says, owners need to pay it or have to pay a certain down payment before you're going to approve a sale. We've seen that. We've drafted that language for clients of ours, where maybe you want to make sure that prospective owners aren't essentially financing 100% of the transfer. You can put in there language that it can't be more than, 90%, 80%, whatever else. What about move-in, move-out deposits? Well, we'd say still you're safer having that in your governing documents. But if it's a refundable deposit, if it's something like, to reserve the bigger elevator, the moving elevator, we ask them to do that. Fine, that's probably okay. What about in the world of HOAs, a capital contribution? That's something too that really for HOAs, it's a little different. Condos, again, the statute 718 has that transfer fee limitation. Condos alone, HOAs do not have that limitation. So in HOAs, 720, you could have a capital contribution. That could be part of your transfer as well. As part of any transfer, you could have language in your governing documents that says every new owner has to contribute whatever it is, 6 months worth of assessments, or maybe there's just a flat number, $1,000, $5,000, whatever it may be. That's language too. If you want to charge a capital contribution, that's language that would have to be in your governing documents. And again, that's something that's really more for HOAs. And there is no limit. Obviously, we hear about some of those associations that charge a lot of money when you want to buy and when you want to move in. And that's completely legal and legitimate as long as it's in your governing documents. All right. All right, so which transfers are actually subject to approval? And it sounds silly, I know, because you say, well, transfers, so we all know sales, leases, right? Well, sales and leases, those are the big common terms that we hear all the time, but what does that really mean? So arm's length sales, that's a normal, normal seller, buyer, typical situation. But what about if your governing documents only say sale and lease, only use those words? What about quitclaim deeds? What about life estate deeds? What about trusts? What if we're just transferring properties because somebody has passed away and there's an inheritance, and just through, the operation of law, the property has been transferred? Do you get to now review that new person, that new owner? Well, there was no sale in theory. So if you don't have that right language, if you don't have the language that really incorporates everything, then you're going to have a problem. So you really want to make sure that the language in your governing documents is the language that you want and is the authority that you want to have. If you're a board that is not so concerned, then that's fine. Then don't worry about it. If you're not really checking sales and every transfer, maybe you're a community that is only concerned about leases, then that language is not so critical for you. But if you want to be reviewing every transfer, transfers is a broad term. So we need to make sure that includes not just sales and leases, but sales, quitclaim deeds, life estate transfers, any transfer by operation of law. So again, if you had a life estate and that life tenant passed away and you have these remainder men now that have essentially become new owners because the life estate person has passed away, do you want to be able to review those individuals? Do you want them to have to go through the application process? A lot of communities now are, the 55 and over communities. Maybe you want not necessarily to be able to review, to allow that person to be the owner, but maybe to review that person, the new owner, to make sure that maybe they just don't live in your community. If you do a background check on someone's, delinquent grandson who now just inherited the property because grandma passed away and he was the only one that she liked and he's on the deed now, and he has maybe some issues, maybe he has a bad criminal history, maybe you don't want that guy living in your community. Well, maybe there's a distinction. We'll let him still own it, but he can't live here. He can't be an occupant, but he can still be the owner. These are all things you can hammer out and put in your governing documents, how you want to review like something like that, a life estate transfer or a transfer via operation of law. What if there is a foreclosure issue? This is another topic to really think about. If you are a community where your docs haven't been reviewed in a while, you don't have any amendments, my guess is the language in there about sales and reviews of transfers, even if you have pretty broad language, even if it says sales, leases, and other transfers, there's probably an exclusion for foreclosures. So when your documents were drafted originally by the developer, they had a different priority than you have living there, obviously. They just wanted to sell those units. They wanted to sell those properties, sell the lots. To do that, they need to make it attractive for lenders. They know that people have to be able to get, financing to come in and to purchase. So we need it to make it appealing for lenders. Because of that, the language that's in your sale lease approval, article, if you have one, my guess is towards the end of that section, there's probably a provision that says there's exceptions to this article. There's exceptions for, who has to be screened and what application needs to be filled out. And one of those exceptions is probably for anyone who is purchased as the result of a, judicial sale or a foreclosure sale. And it may say, variations of this language, but essentially what it means is if there's a foreclosure, so if the, Bank of America forecloses on their mortgage because Mr. Smith didn't pay his mortgage, and Bank of America proceeds and does their whole foreclosure action, and that property goes to sale. Now, could be different, outcomes. Bank of America could end up being your new owner, and Bank of America is probably exempt from having to do any sort of application process, again, based on the language in your governing documents. But now what if it doesn't go to Bank of America? What if an investor buys it at that Bank of America sale? And so instead Bank of America forecloses, but ABC investors are the new owner instead. Well, again, the language is really going to be important here, because does it say that only the lender gets that benefit of not having to apply, or does your language actually say that anyone who purchases at that lender's foreclosure sale gets the benefit of not having to do a whole application? That is usually the language. So again, if you're concerned about these investors coming in, or a random owner or a random new purchaser, new owner that you don't get to screen, you don't have the authority to require that they fill out an application. That's something to look at. That's something to consider and possibly amend down the road. It may even extend further than that. You may have language that says anyone that they transfer to. So if Bank of America takes title, in theory, Bank of America, they're not holding on to these properties. They're going to turn around and want to sell it. So are they going to sell it to, Mr. Smith over here? Or are they going to sell it to another ABC investor or realtor or 101? Do you want to be able to screen that transfer, or as a result of that transfer and that new purchaser? That language may also be in there that is prohibiting you from being able to do that. Or what if they want to lease? What if Bank of America takes title and they want to turn around and rent the property? Are you able to screen their tenant? Maybe not. Maybe not. But it depends on the language in the governing documents, and that's something you really need to look at there. Now, mortgagee exceptions, like I said, that's going to be your Bank of America in this situation. That's what you need to really look at and see what happens when they take title, what happens if they foreclose, what happens if they want to transfer it, and that next step. Do you get to review that sale? Do you get to review that lease? Or are those people, is everybody sort of exempt from the application process? Leases, like we said, leases are obviously pretty common. The lease application process is a little different. You don't have to have that right of first refusal language. You get a little more leeway with reviewing leases. But then the big one too is, okay, what about additional occupants? What about family members? Are you reviewing everybody who's moving in? Or are you just reviewing the name on the deed there? Is it just the new owner? Or do we have to look at, well, they're moving in with their spouse, we want to review the spouse. They're moving in with their adult child, we want to review the adult child. Okay, but they're not on the deed, so they're not the owner. Are we reviewing everyone, basically? Now, what about people who aren't part of the initial application? What if it is a family that moved in the beginning and it was a, husband, wife, adult child? Down the road, husband, wife decide to retire and they move somewhere else. Now you have adult child in the property, and maybe adult child got screened initially because they were old enough and you had them do an application and they were part of the original application. Great. But what if this adult child now has, I don't know, a boyfriend move in with them? Well, this is now years down the road. It's another adult. Maybe this is a 30-year-old man who just sort of showed up in your community. You may have some owners who say, well, where'd that guy come from? Who is he? Do we get to screen him? Well, he's not an owner. There was no transfer. There was no sale of the property. He's not an owner. He's not a tenant. He's not leasing. He's not paying rent to anybody. He just moved in. What does that mean? So he's an additional occupant now. Do you have the authority to review additional occupants? That tends to be a little bit of a loophole, so to speak, where people will say, well, you can review leases, but I'm not renting the property. It's not a lease. It's whoever. Now, we'll also hear of oftentimes when we get to guests, that's the other loophole where we'll hear something like, oh, I'm not renting. It's my cousin who's just going to be there for 6 months. It's my brother who's in from out of town. He's just going to be there for, again, a couple months. Again, I'm based in South Florida, so based on that, we see a lot of these sort of Airbnb and rental. restrictions, but then people trying to sideline all of these restrictions, where all of a sudden everybody has a lot of family members that tend to come visit. So do you want to be able to screen those people? Do we care if they're there? Maybe you don't, maybe you do. If you want to be able to screen them, again, that authority needs to be in your governing documents. Do we care if the owner is in the unit with them or in the home with them? Is that okay? Or, maybe we have a different restriction in terms of if the owner is in residence and an additional family member or guest or somebody comes to visit, fine, we don't need to screen that other person, but maybe we do if they're there over a certain number of days. If they're there for 60 days, we want to screen that person. What if the owner's not with them? What if it does kind of look like maybe they're doing some sort of Airbnb or rental and they're trying to, sideswipe our rental restrictions? So maybe if the owner's not in the unit, we have a different restriction. Maybe we put something in the documents that say if the owner's not in the residence with them, any guest, even if we're calling them a guest, we're not calling them a tenant, and we have no proof that they're paying rent, but any guest who's there over whatever it may be, 30 days needs to be screened. Do you want to be able to screen them? Do you want to require that they fill out an application and do a background check and all of that? What if they're family members? What if they're not immediate family members? What if they're related, not related? These are all considerations. Do you want to be able to check them or not? Do we care if their family is separate exemption? Do you want to say, well, if it's family and the owner's there and that's fine, we don't need to screen them. We just need them to maybe tell us that they're going to be there. Just register with us and let us know so we know who's here versus, but we're going to run a background check on them. These are all considerations, all sort of things for you guys to think about as a board, because again, all of that authority needs to be in your governing documents if that's what you want to do. So like I said, the big takeaway here today is check your governing documents. We were joking before that, it's been years, but I've had clients say to me that, oh, we screen everybody, we check everybody, never a problem. Everyone understands they have to fill out an application before they come in, et cetera, et cetera, et cetera. Well, one time it did come up that they wanted to actually deny someone, and somebody actually pushed back and said, well, wait a minute, you don't have the authority. There's no language in your governing documents that says you can deny this. And then we had to confirm, yeah, you're right. They don't have sale authority. They don't even have lease authority. They just have been screening people for years and it never came up. No one ever challenged it. Luckily, never became an issue until it became an issue. And then we had to tell them, hey guys, you need an amendment to your governing documents. We can't just say, well, we've always done it this way. We've done it this way for 25 years, so we're going to keep doing it this way. No, you need the authority in your governing documents. And we'll hear people say, well, can we adopt rules? Because amendments are really hard. We can't get the owners to approve or to get involved. We can't get enough owner involvement. Rules aren't going to cut it either. You can have some rules to help with some of these guidelines and to kind of, work in connection with an amendment. But ultimately, these are really things that should be in your governing documents, adopted as amendments, put in your declaration. And I know that means your members have to vote, and that makes it a little challenging. But ultimately, if your community really wants these things, they should be voting in favor. They should be participating. If you've sort of gotten too far down the road, then that could be a real problem for you. But maybe this is where you kind of start explaining to your owners, we want to make sure we have this authority. We want to be able to, keep everyone safe. We want to know who's in our community, and we need an amendment to do that. All right. So really, what are your options when you get an application, you get a notice that somebody's selling, we'll say selling a unit or a lot? Obviously, number one, you can approve the transaction. Great, everyone looks good. We filled out the application, nothing strange here, nothing unusual, all good. Great. One option, approve the transaction, everyone moves forward. Second option, you could disapprove the transaction based on good cause criteria. So remember in the beginning I said, to disapprove a sale, you have to have the right of first refusal in your governing documents. Those things have to be linked to avoid a possible legal challenge. Now, you don't always have to exercise the right of first refusal. If you have something that doesn't, essentially a prospective transfer that doesn't qualify under your governing documents, you can deny. So now there is usually language in your governing documents that will give you a basis to review criminal history, financial history, or if there's a violation of your governing documents just on the face of the application, that's a good reason to deny, or if there's false information on the application. So if you're running background checks, you're running financial history, your credit checks, all of that. The other one, like I said, the violation of governing documents is interesting. The easiest example, the most straightforward example to give you is if you're a 55 and over community and you have somebody apply where it's maybe, mom is 70 years old, adult daughter is 40 years old, but adult daughter plans on moving in with her 5-year-old. Well, wait a minute. We're a 55 and over community. We do have someone who's at least 55 who's going to be a permanent occupant, so we can check that box, but there's a bit of a red flag here. We can't have a 5-year-old living in our community. So that would be a violation of the governing documents just on their face. On the face of the application, we know we can't have that here. That's going to violate our governing documents. We could deny the application based on that. Third option, if we don't have an issue with criminal history, we don't have a financial concern, there's no false information, there's no violation of the governing documents. And like I said, the way it usually comes up is typically just based on the sale price. The other option is to exercise the right of first refusal, which means the association is providing a substitute purchaser, right? So like I said, that could be the association, that could be, a friend, investor, somebody else that they happen to know that wants to step in. But we're going to tell you, the easiest way to be reviewing sales and denying sales is if you can fall under number 2 here. So if you can disapprove the transaction based on good cause criteria, so that's something, those are buzzwords. You'll hear us say good cause criteria. We're going to tell you to have us draft an amendment, have your legal counsel talk to you about good cause criteria. The language that's in your original governing documents, even if you have some right of first refusal language and you have everything else in there, odds are there's some basis for, there's generic usually language that says something about maintaining a congenial atmosphere of owners who are responsible and financially sound, or some sort of generic information, something that will give you a basis to look at finances and criminal background. But if you want more detailed good cause criteria, really put that in an amendment, put that in your governing documents, let your counsel help you draft that, because there are certain things we need to make sure the language is okay, and we put in there for you. But we're going to tighten up basically all of the reasons you could deny. And there'll be valid reasons because they're in your governing documents, so that it's very easy to say, well, we can deny the sale. We don't have to exercise the right of first refusal because our governing documents say so, and here are all of the reasons that we can be looking at. And everyone's going to know, everyone in your community now knows what the criteria is and what we're looking at when we're reviewing sale applications. So we can include more detail in terms of what we're looking at with criminal history. We can include more information about financial history and again, what we're looking at. We can list, prior bankruptcies are going to be considered, prior foreclosures are going to be considered. Any fines or charges against the unit or the lot are going to be considered. If this individual has been a prior resident, maybe this is someone who had leased in the property or in the community for a year, and now they're trying to buy into the community. But when they were a tenant, maybe they weren't so great. Maybe you had issues. They already demonstrated that they don't follow the rules. They don't listen to, to the covenants and restrictions of the community. They throw loud parties. They, park on the grass. They do all these things. And when they lived there for that year, they didn't follow the rules. And we have that documented. So we know, well, they weren't good tenants, so we don't want them to be owners in our community. That could be something we include in the good cause criteria. But that's something where you really need to get your legal counsel involved, because odds are you don't want to have to exercise the right of first refusal. You want to be able to say, we can deny the sale, we can disapprove this transaction because of XYZ, and we don't have to exercise the right of first refusal. But that XYZ is stronger if you have that good cause criteria drafted, again, by an expert to and put into your declaration. We tell you when we're talking about criminal history, don't have a blanket policy that just says, hey, if there's any criminal history, we're going to deny this purchaser. That really doesn't cut it. You really need to have some additional factors. So again, this is where you do need to have your counsel involved. So it would be something like, we want to look at the recency, the seriousness of the crime, and any rehabilitation efforts. You know, we kind of joke, but you know, times have changed. Back in the day, you know, possession of marijuana in New York in 1985 was, I think, a felony. Now that wouldn't be a felony, and it was 1985. It was, you know, 30 years or whatever that is, 45 years ago. You know, we want to look at, is that a reason to deny somebody, or do they have a whole bunch of crimes and we want to see how recent they are, how serious they are. If they're misdemeanors, essentially they're not going to count. If it's felony charge, that means it's more serious. That's when we're looking, you know, at the seriousness. And it also has to be a conviction, okay? So when we say we're looking at these crimes and how serious they are, how recent they are, we also mean not just charges. And we have boards obviously tell us, hey, I Googled this person and I found this article that said they were accused of doing horrible stuff. But ultimately, then when we kind of looked into it further, well, their criminal background check actually came up clean because the charges got dropped. Well, you can't just say, well, I Googled it and I found this newspaper article and it sounds like they did terrible things, so we're going to deny them. That's not going to fly. When the actual criminal history says they don't have a criminal record because the charges got dropped. If the charges get dropped, they have a clean criminal history, guys. You can't consider that. So there are different ways to look at all of these things, and you really need to get your counsel involved and make sure that good cause criteria is drafted in such a way that you can deny who you want to deny and you understand what your authority is. And this is why. So we talk about the potential liability if you deny somebody improperly. We're talking potential for big damages here. So if you're denying someone basically, a potential lease, maybe the damages aren't as severe. Although you still may have somebody complain that they lost rental income, and that can be, that could be pretty big numbers. But when we're talking about denying a sale, denying a prospective sale of a unit or of a lot, those are big numbers. If somebody now lost a buyer, has to wait another 30 days, whatever it is, can't find another buyer, has to drop the price, we could be talking, tens of thousands of dollars. And if you didn't properly do that, you didn't properly deny, you didn't have the authority to deny, that owner may come after you. You just cost them $50,000. So, you need to make sure you're not kind of falling into these loopholes here and into these traps. A big issue is discrimination. We obviously deal with that with these claims where, before I said potentially if we have a 55 and over community, the documents are very clear. They're 55 and over. They do their, they do their census every 2 years. They comply with everything they're supposed to comply with. They enforce their age restriction. They're, on the up and up. It's a 55 and over. And we have an application that clearly indicates the intent to move in with children. That is an issue. That would be a violation. Now, if it's not a 55 and over community, you wouldn't be able to say, well, we don't want kids here, so we're going to deny the application. That's a pretty clear issue. That would be a discrimination claim, I'm sure, against you, if that were the case. But there are many different protected classes, right? So the fair housing laws protect race, national origin, familial status. Familial status is also inclusive of, again, so if there are any children involved, and also pregnant women, sexual orientation, marital status, and then disability accommodations. Disability is a big issue. So if we have someone who claims, that they have a service animal, and maybe they do say that it's a whatever it is, it's an animal that alerts me when I'm about to have a seizure, and I have the documentation to show it. And here you go, a note from a doctor, all of this stuff, and you say, well, we're a no pet building, so we're not going to let you come in with the dog, so we're denying the application. That is a big red flag. You're going to run into a problem for sure, because if this person is disabled and they've made this request to you, you have to make that accommodation, and they've given you the support and all of that. You really do need to get your counsel involved, but ultimately your counsel may say, hey, if you deny this, there's a big risk of liability here. You really should be making this accommodation and granting this request. So again, it goes back to, well, you can't deny them as a purchaser because you don't want the dog here. So you have to look at all of these things sort of in context. Now also look at your governing documents. Again, I'm sorry, I sound like a broken record, but look at your governing documents in terms of the timeframes, the notice requirements, because they might all be different. everyone may sort of understand or think, well, we have 30 days to review this application. Board's out of town. We're going to circle back in a couple weeks. We have 30 days. We're good. It's fine. Well, you may or may not have 30 days. It might depend on what's in your governing documents. Now check with your management team. Your management team might be using sort of a generic application that they use for all of their communities. And maybe the application says 30 days. Maybe that's where we all in our minds think the 30 days came from. But is that what your governing documents actually say? Make sure that is consistent. Sometimes your governing documents might say something different. I've seen it where you only have 10 days to review an application, or 15 days, or 20 days. And the language may say, if you don't deny within that time frame, it's deemed approved. We've seen that too, where then a landlord or an owner will come back and say, well, okay, you can't deny my tenant now because it's been 21 days since they sent in the application. And DEC says you had 20 days to respond to me, and it's day 21. So I'm telling my tenant they're deemed approved and they're going to move in. That might be the case. It really depends on the language in your governing documents. You want to make sure you know those deadlines and you comply with all those deadlines. You also might want to clear up, does it say, and I would argue that if it says from the application, that means a completed application, but you'd want to make that nice and clear if you're doing an amendment that it's from when you get the full application, all of the documents, everything's been completed, everything's been executed. You're not waiting for the background check still. You're not waiting for an additional, whatever it is, proof of, a bank statement, proof of income or something like that. If we don't have all of those things, in theory, we shouldn't be making our decision yet, right? So you'd want the declaration that amendment in the declaration to say very clearly, from the completion of the application, from all of the documents being provided, that's when our time starts to run. That's when the window starts. But again, that should be the understanding, but we'd want to make that nice and clear. Again, if you're doing an amendment, why not? Fair Credit Reporting Act, Florida statute, you have to be careful about that too. You can't disclose this information to people when we're talking about credit scores, when we're talking about finances. You have to be very careful. Obviously, that's sensitive information. So again, when we're responding to the owner, that might be different than how we're responding to the tenant or to the prospective buyer. Those are different things. Make sure you don't mix those things up. We don't want to divulge any information that we shouldn't be divulging. As part of your official records, keep in mind, while all of this stuff would be stuff you'd have to keep in your official records, there is language in there in the official records section of 718 and 720 that basically says certain records are not open for inspection. And one of those exceptions there is language gathered in connection with a sale or lease transfer, application. So someone's credit report, someone's background check, someone's, bank statements that you got because they did an application, that's not going to be open for inspection, right? So you're not going to let other owners take a look at that. And that's usually pretty common sense. We know why that would be. All right, guest occupancy. So like I said, guest occupancy, especially in South Florida with Airbnbs and all of this and rental restrictions and people trying to sidestep, rental restrictions, guests become a big problem, right? So again, it's up to you guys. What authority do you want to have? What do you want to enforce? Do we care if guests are here? Do we care only if a guest is here for a certain number of days? Do we care if the guest is here, if the owner's also here? What if the guest is a family member? You can put language in your governing documents because guest is just a term. It's just a word. It doesn't have a definition in the statute. You can put a definition in your governing documents. You can amend your declaration to say anyone who is not an owner or not an approved occupant or not an approved tenant, anyone who is considered a guest is someone who stays overnight and after X number of days, again, draft it, talk to your counsel and see how you want it to be worded. But anyone who is here 30 days, even if they claim to be a guest, even if they're not paying rent, is going to be considered a tenant and has to go through the application process, needs to be screened the same way a tenant would. We want to run background checks maybe after 30 days. We want to make sure, this person who is claiming to be a guest doesn't have a criminal history. But that's up to you as a community. Now, you also might want to put in there, and again, all of this wording is kind of up to you and talk to your counsel about how you want to do it. But is it, if they're there for 30 days in a row, 30 days in a 12-month period. Again, do we care if it's maybe family members? We're not going to screen them. Up to you. Again, all things that can be tailored and drafted in a way that makes sense for your community. Now, what about occupants? So same kind of thing. Like I said, what about that boyfriend who just shows up and essentially moves in, and he's not an owner, he's not a tenant, the owner's in the unit with him. Can we screen him? How does that work? And what about actual occupancy limitations in terms of the numbers of people, the number of humans being, inside a unit or a lot? Can we restrict that? Now, obviously, there's certain code restrictions, certain ordinances that are going to kick in too, but keep in mind, they're not as straightforward as you might think. You might have a restriction in your governing documents that says, 2 individuals per bedroom is our limitation for the number of occupants for a unit. That might be very different than what the code restriction is, technically. You might want to defer to the code, but then you need to understand what the code requirements are. In Broward, for example, I think anyone who's under the age of 10, anyone under 10 years old, essentially counts as half a person for the purposes of counting, heads and beds kind of thing. So is that what we're going to follow? Now, there was a discrimination issue raised based on a couple where the woman was pregnant, and it was a husband and wife that wanted to move in, and it was a 1-bedroom condo. And their declaration had language that said, essentially, our limit is 2 people per bedroom. So we want to deny the application. We can't allow these people to move in because they're going to violate our governing documents. We're denying it. Well, you remember I said one of the protected classes is familial status, and that includes pregnant women. And that went all the way to a court where a judge had to say, essentially, hey, a husband and wife with a baby should be able to live in a 1-bedroom condo. That's just kind of reasonable. Yes, babies secretly take up a lot of room, but realistically, that shouldn't be an issue. So the language really, and there was a discrimination claim raised there because of that. So that's something you need to be careful about when we're talking about the number of occupants in a unit. Is it everyone who's, over 18, not just nobody, or, no one over, no more than 2 people can be in a 1-bedroom unit? Then you might run into this issue. What about registration requirements or overnight guests? Who's using the facilities? Who's using your amenities? These are all things to think about. Again, you could have maybe limitations where we don't care if our owners bring guests. We don't care if our owners have, visitors, even additional occupants, but we just want to know who they are. We don't want to run background checks. We don't need to, have a full application filled out, but we just want to know, who this new person is who's showing up at our pool or who's playing pickleball this week. So maybe you have a registration requirement. And we would say, security wise, that's something that makes sense. You just need to know who that person is. So, okay, Mr. Jones has a guest. His, brother Bob is in town. He's going to be here for 6 weeks. We just need Bob to be registered with us so we know, again, who this new guy on the pickleball court is. We're not running a background check. We're not doing a whole inspection here, but we just want to know who he is, so we recognize the familiar face and nobody's, calling the police because they see a stranger in the community. So things like that, that could be something you want to consider. Or we're not running a full background check. We're just asking them to register and give us basically their identification, their name, and maybe even how long is he going to be here. That's something I think you probably could do by rule, wouldn't necessarily have to be in your declaration. And that's something that really is embedded in the security and safety and welfare of your community. Because again, we don't want a lot of strangers running around, right? There's a security issue with that. All right. So now looking at sort of how we, keep an eye on everybody, what are our practical considerations here? So if we're talking 55 and over, hopefully you guys know you're supposed to still be doing surveys. Okay. So you should know roughly who's living in each home or unit. You should be doing them every 2 years. Now, even if you're not a 55 and over, you may still want to occasionally do surveys so you have an idea of who's here. If you're in a community that has a guard gate, that helps a lot. If you have gate access, if we can register vehicles, if we have key fobs, if you're in a condo and you have a security desk downstairs and you still require key fobs and people coming in and checking in at the gate and all of that, or at the guard gate, Those are all ways we can kind of keep tabs on who's here, when they're here, what's going on, who's in each unit. Lease renewals. This is an important one because this sort of gets ignored sometimes and falls by the wayside a bit. Most people understand if we're reviewing leases and we're reviewing tenants, that's all well and good. But now what if this lease sort of automatically renews? We tend to get to a point where, oh, I don't know, there's a tenant in that unit. It's been this, I think it's been the same tenant. They've been there for 5 years, or have they been? Did we screen them? It was 5 years ago. I think it's the same person. Really, you should be requiring that these lease renewals get processed with your management team, with the board, with the association, so that you do know when that lease is up. Even if it's the same tenant, all well and good. You don't need to necessarily be, running a new application and a new background check, but just have them notify you so you have the new lease. We know that it's the same person. We've had no problems with them. They're a great tenant, all good. But now we know the lease isn't going to be expiring this year. It's expiring next year. We have a new copy of the new lease, and we can keep track of who's in the unit. Now, again, that should be clear because a new lease term, even if it's a renewal, to me, that's a new lease. That is technically a new lease. But owners get confused about that. Landlords, tenants get confused about that. Make sure that your policy is very clear. Lease renewals, you need to be notifying management as well. You need to be notifying the board, even if it's the same tenant and essentially nothing's changed. It is a new lease term. So make that nice and clear in your policies. And that, again, if you're doing an amendment, could be something you make nice and clear in your amendments too. Easiest way you're going to sort of keep an eye on people and who's there and what they're doing, like I said, is through the gate security. If you have gate access, if you have security guards, front door procedures, if you're a high rise and they have to come in and they have to check in. The other one is just in general, the use of the facilities and the common elements. You're going to see people in your community, odds are, at the pool, at the pickleball court, whatever it is, at the gym. So what is our procedure? Do you have a key fob? Are we tracking where those key fobs go? Are we making sure if they're keys that they, can't make easy copies? All of these things, and you're keeping track of all of this. So this is how you're going to know who's in your community, who should be there, who shouldn't be there. Those are really kind of how you keep an eye on everybody. Now, what happens? What's the enforcement option if somebody does have an unapproved tenant or an unapproved occupant, or even a sale that goes through that never got approved? What do we do? So you have a bunch of options here. Arbitration litigation, that's the main one. Obviously, we can actually sue. A lot of times, your declaration, the way the language will read, it will say if this is a transfer of a property, if there's a sale and it's not approved, it didn't comply with this article in your declaration, it's considered void and no good. So they will have a title issue potentially, and you can go after them to say, hey, wait a minute, this transfer was never approved. And there could be a whole title issue because essentially it's void. It's a void transfer. You could send a demand letter. That's what we'd want to start with. Hey, you never applied, or you did apply, but we never approved you, and you still went forward and recorded the deed and did whatever you were going to do. We need you to finish the application or whatever it may be. Now, odds are, if it's something where they just didn't fill out the application or they didn't complete it, you can do it after the fact. If it's an unapproved occupant or an unapproved tenant and they move in first and then you find out, hey, wait a minute, where'd that guy come from? You can have them do the application. If there's no issues, that's fine. You can approve it sort of again after the fact. But if it's someone that you didn't want to move in, if they have a terrible criminal history, they have a terrible, financial history, and they've moved in anyway, and they're a bad tenant, unapproved tenant, what are we going to do? So send a demand to them and the owner. Hey, you got to get rid of this guy. But we might have to take further legal steps, right? So we might actually end up in a lawsuit. Could you evict them? That's what we get that question a lot from a lot of board members. Well, your governing documents would have to authorize us to do that. Typically, we're going after the owner because the owner is the one who has the relationship to the association. The owner is the one who basically has the contract in terms of the breach of declaration. They're the ones who breached it by not complying and not getting the application done, or ignoring the application or ignoring the denial. So we're going to go after the owner. We're going to tell the owner, you got to get rid of this unapproved tenant. We need a judge to enter a judgment against you telling you that you violated the governing documents and making you get rid of that unapproved tenant. But like I said, we get a question, well, can we just directly go after the tenant? Can we kick the tenant out? Can we go through, a Chapter 83 eviction kind of thing? Well, maybe if you have the governing document language that allows you to do it, if the governing documents say you, the board, the association, can step into the shoes of that owner, then we could file an eviction action directly against the tenant. And maybe you have a tenant where maybe they even were approved and then they became a problem. Maybe then they started throwing parties, they're making a mess at the pool, they're parking on the grass, they're doing all these things they shouldn't be doing. And you tell the owner, hey, your tenants are a problem, you got to get rid of them. We've gotten to such a point, they can't be here anymore. We've sent them multiple notices, multiple demands, and they're still doing the things they shouldn't be doing. We got to get rid of them. Well, you might have language that says we can actually step into the shoes of the owners. We can evict these tenants. And it's even better if that language also says, and then the attorney's fees that the association had to incur to get rid of the problem tenant, we can charge back to the owner because the owner really is responsible and the owner should have gotten rid of them. But that's language that would have to be in your governing documents. You can't just do it. Otherwise, like I said, we're going after the owner and making the owner go after the problem tenant. Other sort of simpler options, we can deny access. You can, shut off transponders, shut off key fobs. That makes life very difficult if we have problem people and now all of a sudden they can't, go through the guard gate. They have to stop and talk to the guard. They can't use the key fob. They get very annoyed about that. You can't deny them access altogether if they're living in the community, but you can make it much more difficult and you can deny them access to the gym. You can deny them access to the clubhouse if you turn that key fob off or that key card or whatever else it is. Now, can you get back your costs, your damages, your attorney's fees? Potentially. So again, if it's a breach of your declaration that we're alleging, then yes, you should be able to recover those attorney's fees back from the owner. Now, again, it's the owner that had that relationship with you, right? So that's the person you're going to go after for any fees. Now, do you have language there that maybe says something even more that says, if we have to send even a letter, if we have to get the attorneys involved at all, but we don't even have to get to the court phase, if we get the attorneys involved in a pre-litigation, posture, you could have language that says, owner, you're still responsible for those fees that the association has incurred. Because usually, if we get to the point of litigation, we're going to make an argument that we can recover fees. Okay. But what if we had to send a bunch of letters? You had to get the attorney involved, but we never actually get to litigation. That's where you want to have extra language, that sort of extra language in your governing documents, which is something you're probably going to have to add as an amendment because that's usually not in there by itself. All right. So last slide here. We keep it under an hour for you guys and then we'll get to questions. But bottom line, like I said, and I know I sound like a broken record, confirm and create the authority that you want. Look at your governing documents, see what your governing documents actually say, what they allow, who you can screen, who you want to screen. If you're missing anyone, if you're missing sort of, like I said, even a quitclaim deed or an inheritance or any of those scenarios that maybe you want to address, that if you have old language might not be covered on there, or if you don't have right of first refusal, that's a big one. That's a big red flag. Talk to your attorneys, draft an amendment, make sure your governing documents have the authority that you want them to have and sync up with what you want to be doing. And then establish procedures, documentation, talk to your management team, make sure the application kind of syncs up with what your restrictions are, all works with your governing documents together. If you have certain rules, certain criteria, include that in the application so everyone knows what what they're getting into here. And then they can't say once they move in, oh, I had no idea that you guys were a no pet community. Well, we told you 800 times and it was on the application too. It's in the declaration, you should know, but it was also on the application just to make it crystal clear. And then apply everything uniformly, consistently. Ultimately, these applications are going to be sort of looked at on a case-by-case basis. Nobody is going to have the exact same financial history, the exact same criminal history, but you still want to have this criteria that you are applying across the board. And then, how are you doing it? Do you have a screening committee? Is it a board member that's making the decision? Are you doing these at board meetings? Get with your management team, make sure you've sort of set this up, how you're going to carry this out, and understand, again, the extent of what your documentation lets you do, the authority that you do have under your documents. Make sure it syncs up with what you want. Talk to your attorneys, get your documents amended if you need to. And again, I know you're going to tell me that's hard to do, but here we are. So that's it. All right. Do we have any questions, guys?
There are a few, and I'll let you and Eric get to that in just about 1 minute. So please
All
look over
right.
the questions, you guys. While you're doing that, I want to mention to everybody that if you haven't already, press the chat button so it appears on your interface. We've already placed the link for the evaluation there a couple of times. We'll do it again because if you just press chat now for the first time, you won't see what was there previously. So if you haven't already done so, please press chat now so it shows up. And then in about a minute, I'll place the evaluation link in there once again. Now, the Q&A is bonus. We'll get to as many Q&A questions as we can, but this is not a requirement. The slides are done. After you do the evaluation, you are free to go. We want you to hang out, but again, you don't have to because I know that comes up constantly. So again, press the chat. Eric, Emily, back to you both.
All right. I see some good questions in here, guys. So, Eric, do you need to say anything before I start kind of going through?
No, I'm looking through some of these questions. They're really good questions.
Yeah.
I like to see it because it means everyone was paying attention. They were absorbing it. So most of these are going to be, they're going to fall squarely within your area of expertise, but I'll be here to assist if I can.
All right. So someone said, and this is a good question. I think we did cover it a little bit, but I'll just sort of reiterate. If you're a 55 and over and someone inherited who's under 55, how does that work? What rules? The declaration or the documents or Florida law? So again, the under 55 becomes a bit of an issue, right? So we know for 55 and over, technically one permanent occupant is supposed to be at least 55 years of age. So now we get into sort of the occupancy issue. So someone who inherits who's under 55 could own the property. That's fine. I always make the joke that I could buy in a 55 and over community. I'm hoping it's very clear that I'm not 55 yet. Although as I keep making this joke, I'm slowly, inching closer to that. But I could buy in a 55 and, for my mom could move in, my dad could move in, and arguably I could move in with them. I wouldn't want to, don't tell them that, but I wouldn't want to. But if it's someone who inherits who's under 55, it's not the ownership that's the problem. It's the occupancy that's a problem. So maybe it is something where, okay, new owner, Mr. Jones's grandson or son, you can own it, but you can't live there by yourself because you're under 55. Or you could sell it, you can rent it, you can have somebody else move in. If you want to move in with another family member or somebody else, cool. But obviously we'd want to see what the story is. Now, again, that's something where we look at your governing documents, but your governing documents, I'm sure, probably sync up to what the Florida law is and what the fair housing laws are, or not fair housing, the 55 and over housing laws are, where essentially one permanent occupant is supposed to be at least 55. So that's a perfect example. That person can own it, but they can't live there alone because there's an occupancy requirement. So, but interesting. And we would want to make sure, again, that you can review that transfer. That would be something you'd want to put in your governing documents. All right. So somebody is asking about a rental moratorium. They said homeowners renting their unit, he's going to sell. We have in our documents, the homeowners have to own the unit for 2 years. So basically, does he have to kick the tenant out before he sells it? Now, I would hope, and I would tell you, talk to an attorney to see what the language is. But when we draft rental moratoriums like that, you can't rent for the first 2 years or the first year, we typically do include language in there, but maybe your documents don't have it, that will say, if there's a current tenant, we let that current tenant, as long as it was an approved tenant, stay and finish out the lease term. And then we'll have the 2-year moratorium pick up, because it does seem a little unfair to sort of kick a tenant out in the middle of a lease. But at the same time, that new purchaser still needs that sort of 2-year moratorium. So if we let it start 6 months later, really there's no harm, no foul. That's how we would draft it. But if your language isn't drafted that way, then talk to your attorneys, because maybe you want to sort of create a policy clarifying how you're going to enforce that properly. It does seem a little, unreasonable to say to an owner, well, you got to kick your tenant out before you sell the unit. So, but talk to your attorney about that one. All right, let's see. What about those that are leasing or have a guest and a pet that's not allowed, even in the docs, no pets? So when we talked about pets, again, pets get confusing when we start talking about disabilities, and then they're not pets if they're really, assistance animals. But let's say we're just talking pets here, and there's no question about a disability, there's no question about a reasonable accommodation. If we're just talking pets, your pet restriction should be applied across the board to your owners, to your residents, to leases, to tenants, to guests. Now, again, if they come back to you and say, well, it's not my pet, it's actually my assistance animal, and I need you to make a reasonable accommodation, and here's my, documentation that supports that, then review that with your attorney and see if you do need to make an exception potentially. But ultimately, that sort of restriction should be applied across the board. If you have a separate policy, for your owners versus your tenants, that's going to potentially be an issue if it's only in your rules. If it's in your deck, that would be allowed. You could have something in your declaration that says owners can have pets, but we don't want tenants to have pets. You could have language like that, but that would have to be in your declaration. You can't just sort of create that policy. So lots of considerations there when you're talking about it. And again, talk to your counsel, see what makes sense for your community. Somebody
Emily, I
asked,
want to
yeah,
jump in real quick.
yeah,
Because we hear a lot with boards, and I just want to reiterate the fact, as a management company, right, we get a lot of requests for a lot of different things. And in the past, with the regulations and kind of how things have changed, now there's new language that makes board members liable for decisions that they make, right? And so as a management company, we get asked all the time, well, what should we do about this? What should we do about that? In the past, it was always just kind of like certain boards would just go, oh, well, that's how we've always done it in the past, and that's how we're going to continue to do it. That cannot be your standard operating procedure anymore, right? We always make the case, involve your counsel.
Yeah.
Run it by them, talk to them. They are the experts on your documents. They are going to give you they are there to protect the association, right? To keep you out of trouble. If you need to adjust your budget and add a larger line item, right? It's going to help you in the long run, right? Involving your counsel is going to prevent you from having more costly mistakes, right? So we always stress that if you're not sure, 100% as your manager, we're going to tell you, go to counsel. That should be your go-to response, because a lot of this stuff can trip you up on a lot of things when you're talking pets and everything else. You have an expert, they work for you, make sure you use them.
No, thank you for saying that, Eric, because it's true. I mean, we know a lot of boards, obviously, sometimes they'll just talk to their managers when they have questions, and that's great. But I'll hear it too from managers who will say, I try and tell them to go to the attorney too, because this isn't for me. This is a legal question, but they want to figure out themselves. They don't want to spend the money. They know you guys charge. They want to save a couple bucks. But this is one of those topics where this is, fraught with minefields. And like I said, potentially, if you deny the wrong person or say the wrong thing when you deny someone, you could be hit with a discrimination lawsuit. You could end up on the wrong side of some other sort of claim that it was an improper denial. And like I said, I couldn't sell my property now, and I had to drop the price, and I lost my buyer, and you guys cost me $100,000. So, you might save whatever it is, $500 asking me the question, but now you're being sued for $100,000. So, you have to kind of think about it that way. Now, again, talk to your management team. Obviously, they're there for you on a daily basis, but if your manager especially is saying, hey guys, we need to get the attorney involved here, you are on a board, you're a volunteer, you're not expected to know everything, you're not expected to be a legal expert. But you do need to rely on your experts. You need to get us involved when these types of things come up, because I mean, I have a client now that even though they didn't do anything wrong, they have a problem owner who's suing them because he thinks they denied his tenant improperly, and he hates the board hates him, and he thinks that's why they denied it. So they're going to deal with that. They have insurance defense handling it, but even that's annoying. Even if they win, they had to spend money to deal with this guy. So, those things come up all the time. Get your counsel involved, get your experts involved, and we'll try and keep you from getting sued where we can. So, yeah. All right. Do we have any other big ones? Someone said, okay, the right of first refusal, someone said, can you please just clearly explain? So let me say it one more time. Your documents should spell out what the right of first refusal is, and should spell out that you have it in there. If you don't see anything involving the words right of first refusal, get with your counsel, because that's step number one. But ultimately, what it means is the board can only deny and not have to provide a substitute purchaser if that sale, that transfer, does not comply with the governing documents, doesn't qualify under the governing documents. In every other instance, if the board denies that sale, they have to provide a substitute purchaser who's going to step into the shoes of that prospective buyer and complete the sale the same way that that application basically spelled it out. So if you had someone who was going to buy, Mr. Johnson was going to buy, and he was buying this unit for $200,000, and the board doesn't want to approve it because $200,000 is really, a low price. These are going for $4,000, and we don't know why he's only selling it for $200,000. But Mr. Johnson has good credit. There's no criminal history. There's no issue where you could say we're denying this because Mr. Johnson's a bad applicant. The board might want to step into the shoes. If they want to deny it, they have to step into the shoes of that purchaser. They have to provide a substitute purchaser for Mr. Johnson, who is either, again, can be the association, or could be someone else, an investor, somebody else they happen to know. And then they're going to step in and complete that sale. So the seller, the owner, still gets the same money that they were going to get, because it's the same sale price. And now you've stepped into the shoes, you've provided the substitute purchaser. So the original purchaser goes away. They're out of the scene. But now the substitute purchaser, probably the association, purchases that unit for $200,000. Again, usually only done really because there's something with the sale price, typically. That's really the only time I've seen the board really do it that way. And then they turn around and properly, list it and sell it for the higher price. Not always. You could also just do it if if something just doesn't smell right with the application and you have nothing else to point to. You could say, we're denying it and we understand we don't have good reason, so we have to exercise the right of first refusal. Those things have to be tied together. Or you have to deny, and it has to be based on that purchase doesn't qualify under the governing documents. We have our good cause criteria, and here's the reason why. But if you don't have a good reason, you're exercising the right of first refusal. Hopefully that's clear. I know it is a little tricky, but here we are. All right, somebody said, all right, so some of this is getting into little kind of specific details about criminal history, credit report, things like that. And I don't want to go down kind of into the weeds with some of these things, but talk to your counsel. If there's something that jumps out at you with an application and you're not sure if it's enough, if it's a good enough reason to deny, talk to your counsel, get them involved. All right. If an owner, this is a good scenario too. If an owner suddenly becomes disabled and a family member has to come take care of that owner, does that family member have to be screened? That's a good situation too. And I would ask you that question too. What do your governing documents say? Does that family member need to be screened? I don't know, because I don't know what your governing documents say. Maybe, maybe not. But you want to make sure, again, that's something where you want your governing documents to say what you want to be doing. You will make sure those two things sync up. Whatever authority you think you have, hopefully your governing documents actually say that. If you want to review that and that application and require that family member to apply, then you have to be able to say, here, our governing documents say you have to apply, even though you're a family member. Or maybe not. But up to you, should be in your governing documents. That's the only way we would know. What if they're staying for a couple months or maybe less? Same thing. It has to be spelled out in your governing documents. If you don't have language that says we review everyone who's here over 30 days, something along those lines, then you might have someone say, you can't review, but it's my guest. You're not screening them. They're not a tenant. You only have the authority to review tenants. You need to make sure your governing documents say what you want them to say. All right. Let's see if there's anything else that we...
There was one I saw, it was actually just a few down from the one you just read from Emily that possibly might be good to address.
Oh, which one? Let's see. Oh, possible.
Is it possible to deny a sale or rental based on disruptive behavior based on religious beliefs?
Oh, that is fraught with
Danger
difficulty there. So Yes. So the issue, obviously, and I think you realize what you're hitting on there. When we talk about religious beliefs, then we're sort of triggering, is there going to be a discrimination claim based on whatever the allegation is? So again, I'd want to know more on and really look at this on a case by case basis, but you have to be very careful. Obviously, if there's a religious component, that person may come back and say, well, you only said I couldn't live here anymore because I was X religion. Or, you only said you wouldn't renew my lease because I put out whatever it is, I put a cross out on Easter, and you guys are whatever it may be. So the religious part, obviously, that's something that could raise discrimination claims. So we want to be really careful, but we'd want to know also what does that mean, that they're being disruptive based on a religious concern. But you may have to address it. You may have to allow for some sort of accommodation, but we'd need more information on that. But that's an interesting one. That sounds like there's probably a fun story behind it, to be honest. But I know.
Fun being a relative term for Emily
Right?
and I.
I'm sorry. I know some of these stories, though, I'm like, ooh, that's a good one. But yeah, I know you guys, this is also what makes this fun. When I teach this in person, we end up kind of, chatting for another 30 minutes because everyone has an interesting, or to me, fun hypothetical situation that makes for a good story, right? So
I always tell everybody, thank you, because all of you guys' story is going to be great material for me when I write my book, when I retire for
yep,
property management.
yep. So,
And
all
that will
right.
be
Well, I
quite a
think
book
we've
because the
covered them all
stories.
pretty much. I know we missed some questions, but a lot of this is sort of, duplicate. So thank
Yeah.
you guys.
There was one for, I don't know, Emily, there was one there for if governing documents are silent relative to Verbo and Airbnb,
Ugh.
how can HOAs restrict usage without doc amendments?
This is the problem. Ultimately, you are probably going to need an amendment. If you have the language, something in there about, and maybe it doesn't necessarily say Airbnb or VRBO, but maybe you already have language that says the rent has to be at least a 30-day term or something like that. The lease term has to be at least 30 days, or one rental in a 12-month period. Maybe you already have something like that, and without, actually addressing Airbnb and VRBO, based on what everyone has observed, clearly you have a tenant there that you're having tenants there more frequently than once a year, or you're having tenants there that are only coming for 2 weeks. But proving all of that gets very tricky too. This is the other part of it. When we're talking, from an attorney side of things, we always need documentation, evidence, all of that. We can't go in front of a judge and just say, well, we think they're renting it, guys. So they probably are. That's not going to cut it either. So this always gets very tricky because you do need affidavits, you need witnesses, you would need people who have observed, oh yeah, I talked to the guy who was next to me. He came in with his suitcase, with, a rental car, with his Mickey Mouse t-shirt. He was really excited to be here for a week, and then they're going to Orlando and they found this place on on some website. Great. If someone says that to you, now we have a witness who can say, yes, now we know they're doing a rental and it's an Airbnb or whatever it is. But if you don't have that and the owner just comes back and says, oh, no, that's my brother, he was in town for a week, you're going to have a very hard time proving it. So proving these, people who are trying to kind of sidestep the Airbnb and the rental restrictions, the biggest tool you have is if you can do the amendment where we're basically screening everybody, where everybody who's there over X number of days gets screened. That's the only way to kind of keep tabs on it. I know. I don't have a good answer for you. I'm sorry. But yeah.
All right. Looks like you guys can get back to your day and see your clients and tend to your meetings. We thank you both. Eric, thanks for having us. We appreciate the collaboration as always.
Always a pleasure. Great team. I love recommending KBR. As I mentioned before, right, you guys, it's very important. Talk to your counsel, talk to your attorneys. Don't wait to get them involved. They will save you in the long run.
Right.
As a management company, we're huge proponents of that. We're going to recommend to our boards every single time. So having a great partner like KBR, we're proud to host, and we love bringing you guys the content. Education is key. So thank you again.